que este viaje te va a enamorar.
Damn, Pappy, nah, it's been on you all night.
Yo, baby boo, you know that I got you.
You know you are so sexy.
Oh, by the way, what's your number?
508, I'll give it away.
Oh, for sure.
Keep it on the low, alright?
Kiana!
Done dirty. The way you look, the way you dress, it has me speechless. I can't wait, won't hesitate to sharing your caress. I get the butterflies when you're around me. I'm so curious and wanna take you home with me.
Llegando al mundo de la fantasía, para que te des de cuenta que entre tú y yo, mujer, el mundo vamos a recorrer en primera clase, para que nuestras pasiones se puedan desenvolver. Y no es nada raro en cómo todo empezó. Tú me gustaste y yo te gusté. Ahora es que es cámara, luces, acción. Y ten cuidado que el volcán está haciendo erupción.
Let's do a quick mic check. Big shout out to everyone here. Thank you for being here. We appreciate it. As always, the host of the most, the yin to the yang, the team to the tango, Jrod on point. We here. We're gonna do part 2. Thank you though. We appreciate it. Big shout out to Amy Conway. As always, our superstar moderator. Very appreciated as always. As many other moderators gonna start trickling. We got 15 people watching, 13 likes. Very appreciated. That humbles me. You know, we're not always here live, but when we are, we try to give you the best entertainment and information available in true crime, in the true crime community. So big shout out to Amy Conway. She give you some number 1 for good sound. Thank you so much. Let's see. I refreshed the page. We got 17 likes. Thank you so much. Very appreciate it. That means a lot. How Amy Conway is doing in Costa Rica? How's the weather? We got earthquakes in New York and shit. Don't get me started. Relax, dog. Don't get me started. But yeah, we got earthquakes in New York. You know, I get concerned because I got family members in New York, New Jersey. Big shout outs to y'all. So yeah, we got earthquakes in New York. This shit crazy. I mean, New York is as solid as a rock. Like literally, the foundation is just, and it's like it's a fault that no one talks about. Oh my God, I'm talking about something serious. I don't even know why I'm laughing, but you know that through the storm, you gotta look at with a good face, right? So yeah, it's pretty crazy though. They say that for that area to be having earthquakes like that, you know, something It's been like what, 2 in the month. Listen, we're praying for safety, and we're praying for everyone that is around earthquake areas. But yeah, hopefully that's it, and they don't get like a bigger earthquake following those. Hopefully, everything is done with that for long years to come. But hopefully, they don't have a big one on the way. We're praying for that. Because again, we got family members in the area. We're praying for everyone. Thank you so much. But let's move on and get back to work. Let's get back to work. Let's see what we got here. Yes, we got the solar eclipse tomorrow. We're gonna be watching with the safety goggles. We're gonna be watching everything and paying attention to what's going on. Hopefully we go live also tomorrow, because I know for a fact it's gonna be a part 3 of this conversation, due to we get into in details of the analysis of these footages and stuff like that. Again, big shout out to all the other parties involved within this case. Again, I want to repeat to everyone that like what we do here is our personal opinion due to the information available. Yes, we do have very strong takes, and our opinions are based upon what they're showing us. I could only give you my opinion. I could only advise. I could only quality control it. We are unbiased, very unbiased. Because I can't look at it. To be fair, I can't look at it any other way possible. I have to be unbiased. And Amy Conway ready for some homework. Amy, I promise it's not gonna be that long, because again, we kind of like a little bit almost there and halfway. So we probably cover whatever is missing out of this live stream, and because this one is gonna be very, very important. This one is gonna be very important because it's the beginning of the conversation within the change of venue. They were waiting for Superior Court response. Superior Court already responded. They kept it in district. So then now they have the emergency hearing down there and all that. But this is the very beginning on the change of venue hearing, which the survey became an issue. But if you ask me, the survey was not an issue, because if the survey was an issue, prosecution and the court should have a bigger issue with news media outlets, major or small YouTubers, or all cyber sleuthers and personalities in the true crime community on all platforms. They should have a concern on who's saying what and what's their sources. Because no one should have a problem. Because again, if you ask me, in my personal opinion and the knowledge that I have, news media outlets only go by whatever the state, law enforcement, prosecution side of things. They allow the defense to say something when they're available to say something. But news media outlets, when they say sources, 9 times out of 10, they come out of the state. That's why you see their narrative is very towards the state side of things, very biased. Again, the Nancy Grays and the News Nations, big shout outs to ya. Many other content creators in YouTube or somewhere else. When they go within details about Kohberger's guilt, right? And have like the power and the guts to say what they say. And major news media outlets are supposed to have a reputation. That's why people, 9 times out of 10, even though it's well known that they pass something on the Senate that allow the media to do have an agenda, allow the media to lie to people. Propaganda that was signed in the Senate and signed by the president at the time. No need to mention no names. Let's not go political right now. But it was made law that the news media outlets wouldn't get in trouble for lying to the people. The same way cops don't get in trouble when they lie to the people within the middle of an investigation. They're allowed to lie to you and they will not get in trouble. So I said that to say this. With the survey, if the state had any problem with the questionnaire, they shouldn't be mad at the media and those in the media that they share the information to. If it comes from the FBI, if it comes from Moscow PD, if it comes from the state troopers, if it comes from the court, if it comes from anywhere from the prosecution on the hush-hush. If prosecution and the court had any problem with this survey, they were supposed to go to the root of the problem and not have a problem at all with the survey. Because the survey is only the result of the dirt that they have put themselves out there. Because again, news media outlets, they don't go by any source. And especially when it's like secret sources or stuff like that. They go by sources close to the state. Law enforcement, prosecution, court. Very rare they allow the defense to come up and talk. In this case, this particular case, in the Bryan Kohberger case, you could tell how biased news media outlets are within Kohberger's guilt, with none type of discovery, sufficient discovery. They would tell the people, okay, this is something solid in court. Because anything could be said out there. And we understand that. Anything could be said out there. But when you have such a major platform, that millions of people are looking at you, even if you're a small content creator, when we in true crime, we should speak with the most unbiased and the most pure eye, to be fair to all parties. To be fair to all parties, because again, a lot of people, we understand that they got to a point that not supporting and not liking certain content creators in YouTube true crime due to that they in favor of give benefit of the doubt and look at both sides of the fence. Unfortunately for the state, this one particular case, the Idaho 4 Bryan Kohberger case, the state don't have nothing to make him look good. They don't. I cannot sit here and tell you that, yeah, the state has a solid case, because they don't have a case. This is why they've been delaying justice. This is why they're playing dirty tricks in the court, with the court. And this is what we are today. I've been telling y'all since day one. For those that been paying attention and listening, I've been telling y'all since day one. What was about to happen with all this stuff. Because soon as I seen the day went the opposite way, I knew that nothing was about to get fixed. I knew that everything was about to like just take a long trip. That's what I said. I think in the live stream a long time ago, I said that hold on, buckle up, because it's gonna be a long ride. Yeah. So let's without further ado, let's get to the conversation. Let's listen to the court. This is gonna be the prelims towards the big conversation in the next video about the survey. And again, I want to be very, very clear. Our takes, our opinions, our everything that does is belong to us. It belong to us. My opinions, my theories, and what I have to say is all me. So unfortunately, there's gonna be people out there that is gonna get their feathers rough and stuff like that. But again, I would like to people to look at it like, what about this was you? What about if you was Bryan Kohberger? Bars. Let's think about that for a second. Big shout out to everyone watching. It's Jrod on point. Let's get to work. Big shout out to Amy Conway. Big shout out to the 15 people watching. Thank you so much. Very appreciate it. Thank you for spending time with us here, having a conversation. And even though if you're not in the chat, at least just sit back, relax, and watch me work. It's very, very appreciated if you find some value in the conversation that we have here today or any other day on live streams or videos or shorts. Make sure you hit the like button, share the content, and if you have an extra change, you could drop it right there on the Cash App. It's very appreciated. Thank you so much. Click like, subscribe, and share. Very important. If you support us, it's very, very appreciated when you not just click like and share and subscribe and all that stuff, but comment. It's a lot of people in the comments. It's very appreciated. A lot of positive, a little bit of negative, but it's more positive in the comments than negative, which is very, very, very appreciated. Thank you so much. So without further ado, let's get to work and let's listen to Layton County.
Anything else about that, Ms. Taylor?
No, thank you, Chair.
Mr. Thompson?
No, sir.
All right, I think we're now to schedule. Starting with, there was a request on change of venue, maybe late April, you were saying.
Yes, Your Honor, either that last week of April, I think it starts the 29th and 30th, or the first or second week of May for the actual hearing. is when we'd request. And we would ask that we have until maybe the second week of April to get our initial briefing in, and then the state's response and our reply after that.
So what are you thinking would be the hearing? Like, give me a day or a week.
I would say that first full week of May, maybe that's May 5th or May 6th.
Yeah. All right, thank you. Okay. Beatty, Ben? Right?
Your Honor, we're asking the court to either deny this motion for change of venue as premature or to set a hearing date closer to the trial date when that trial date gets set. And the reason for that is when courts look to change of venue and whether or not that's appropriate, the courts look to affidavits that have been filed. Importantly, they look to what jurors say, prospective jurors say during the voir dire process. Another thing that courts look to is the amount of media coverage and the proximity of that media coverage and the intensity of that media coverage to the trial. So in this case, I think we don't have sufficient information to even determine whether or not that's appropriate without seeing what that person.
I want to highlight something that I think is going to be very important. Let me replay this real quick.
Right.
Your Honor, we're asking the court to either deny this motion for change of venue as premature or to set a hearing date closer to the trial date when that trial date gets set. And the reason for that is when courts look to change of venue and whether or not that's appropriate, the courts look to affidavits that have been filed. Importantly, they look to what jurors say, prospective jurors say during the voir dire process. Another thing that courts look to is the amount of media coverage and the proximity of that media coverage and the intensity of that media coverage to the trial. So
let's be clear. The state is fully aware of what the news media outlets are talking about. They are fully aware. So if the state is fully aware of the conversation and news media outlets about the case, how can they have an issue or make their survey an issue when the survey is the product of a well-known problem that the state has not made an issue about when it's convenient for them? We only see the prosecution try to intervene in a major way. They want to dismiss without a hearing again. They're requesting the judge to dismiss that request. For them to want that dismissal, they definitely want a hearing for that. So they don't want to set a day for a hearing for a dismissal of that. They want the judge to dismiss it without looking at it. Again, we could tell that this is like a prosecutional problem, having the prosecution enforcing their will and the court allowing it. In my personal opinion, that's a problem. That's a problem. Because again, we already know that they just deny the motion for dismissal that Ann Taylor presented to the court without a hearing, without listening to the defense. The judge denied that motion. Red flags like that is being happening for a long time. So the state is fully aware of what's out there in the media. They didn't have a problem with that until it was not convenient for them. And then they made the survey problem and try to make the defense look like they violated due process and that they violated the non-dissemination order. When if you ask me, not just the court, but the prosecution are violating due process because they put in through legal, there should be legal loopholes. They've been postponing and delaying, try to make themselves look like they're ready, but at this day to day, as we speak, they still don't have a full discovery out there available for the defense to take a look at it and get their innocent stage out the way. Why if we try to cook this guy, prosecution doesn't look like they in any rush to get to justice? And that's just a fair assessment. It's just, again, my opinion due to the stuff that they putting out there, the conversation out there, how the court is being handling the record. Is not looking good right now. Let's continue. Again, just pay attention. The state know what's out there in the news media outlets, and they didn't have a problem with that until it was not convenient for them when the survey came in and gave the judge what's going on. Oh, then now is a problem. Now the defense gonna take some heat for it when this is what's out there from the media, which the state is well known that actually the state has helped to push those narratives on the media. Because again, the media only go, even if it's confidential sources, they only go by the state side of things. They talk to law enforcement, ex-law enforcement, they have connections within. That's the news media outlets. Amy Conway. BK right is from him to be heard through his counsel by denying the judge not giving him his right. Yes. Again, it was a big red flag when the judge laughing, he said, like, he asked like whose rights we violating here. And he said that laughing with a smirk, like, come on. You know, I'ma say this one thing, this assessment that I have about Judge, but I'ma save that assessment to the very last because I want to make sure that I'm correct. Big shout out to Super Creeker. Thank you for being here. I appreciate it. Thank you for being here. Big shout out to Super Creeker. Yeah, Amy Conway. You know how it goes. Very appreciate it. But big shout out to everyone that is here watching. Thank you for being here. Very appreciate it. Thank you for your subscription. So let's get back to work and listen to what the court got to say.
In this case, I think we don't have sufficient information to even determine whether or not that's appropriate without seeing what prospective jurors actually say. But B, we're far enough out from trial that we can't really gauge that anyway. So we would ask the court to either deny that motion at this time or to set a hearing further down the road and closer to trial. If we do proceed to hearing, the state would just ask for a scheduling order. At this point, the defense has filed a motion. They did not file any affidavits, disclose any experts. They haven't even filed a supporting memorandum. And so we're not even sure what specific cases they're relying upon. So we can't really respond substantively to that motion until it's briefed. So we would ask the court to set a briefing schedule as well. Thank you. Thank you, Your Honor.
Okay, thank you. Well, my interpretation was that they were going to give us a lot of information, affidavits, maybe testimony, for the hearing. Is that right, Ms. Taylor?
Your Honor, you're right. The motion was to put everybody on notice that we'd like to have this addressed. We do intend to have a presentation for the court. We do intend to have briefing for the state. I anticipated we'd get that scheduled today. But no, I didn't file the motion. I filed it to put everybody on notice that it's coming, and I think we need to address it. I think we need to address it before a trial setting. It doesn't make sense to set a trial, get right up to it, and then have to have everybody who's under subpoena rescheduled and have to have the public and the families of everybody disappointed because we're going to reset it at the last minute. So I think we should take care of whether or not the court should change venue sooner rather than later, especially given the length that this trial is anticipated to go. We'll need to schedule a courtroom either here or in another county in Idaho. And we'll need some advance notice to get that done. It'll take a long time to try this case.
Thank you, Ms. Taylor. Thank you, Ms. Beatty.
And Your Honor, the state is asking for a briefing schedule so that we're not in a situation where the state is learning for the first time during a hearing what experts the defendant might be calling and what their arguments are. We would ask that all of that information be disclosed prior to hearing, including the CVs of any experts that will be testifying.
Well, that's certainly what I would expect. But it's quite sticky, right? To think, you're going to wait until ready to seating the jury, which is probably a 2-week process in this case. And then figure out, hey, we can't see the jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to see the jury? It's really a catch-22.
And all of the logistical concerns that Ms. Taylor is describing are totally correct. The problem is that is what the law requires, and that is what the case law says. The case law does contemplate that. So certainly it's correct to note that there are going to be logistical challenges to that, but that's what the case law requires. But even if the court weren't inclined to wait until we're actually going through the voir dire process, at a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process.
Okay. This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that, and then it came up again when they were trying to seat the jury, and then the judge denied that at that point. But kind of a double step to figure out if it was necessary. I've been struggling with this, for 12 months, and so it's hard to know. Now, that doesn't mean that one of the parties can't present evidence, and the standard is kind of squishy, in my opinion, but they can provide that kind of information well before the trial. At the same time, I want to make sure that the state has the opportunity to respond to whatever information Mr. Kohberger is going to present. So now I'm scratching my head about, is May, first week of May, does that allow enough time? Does that allow enough time for you, Ms. Taylor?
Your Honor, I think it does. I can present the information to the state. I can have my briefing, and I can have affidavits and let them know of any witness that I want to call. I can do that probably by the beginning of the second week of April. And that would give them, if we do this in May, that would give them ample time to read it over and respond to what we intend to present.
Thank you. Ms. Beatty? What are your thoughts?
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that. The state would just have concerns about those factors that the courts require us to look to as far as the timing of the hearing compared to the timing of trial. But as far as a briefing scheduled prior to the hearing itself, that timeline makes sense to the state.
Well, let's explore that just for a moment. Because I've been thinking about the setting of trial. Well, also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson in our last hearing, and I really, it wasn't clear that I'm not really happy about setting the trial in 2025. It seems so far away. Now, it's not just, doesn't just affect Mr. Kohberger and his defense, but there's a lot of other considerations. So I am trying to be fair and realistic, okay, about when we could really be ready for trial.
Well, if you ask me, if the judge was so concerned on how quick things gonna move along, in my personal opinion, the judge should have a conversation with the prosecution and find out what's their problem. A deadline for discovery should occur a long time ago. We have seen the prosecution put road blockages all the way through. And it's a fair assessment to say that this might will start by 2020, by 2025, but at the same time, in the way the prosecution being stopping the progress, it's a fair assessment that 2026 might be a fair assessment due to all the prelims and the conversations and the hearings that are going to occur way before that. Again, we still give Aunt Taylor the benefit of the doubt because she could only work so much with what she have available for herself and what they allowing her team to do, which is sad to say that we see the defense team under pressure from the state and the court allowing it. That's a problem. That's a red flag. Again, the judge could see the record, the merits, the transcript, and the judge should be fully aware of prosecution tactics and was malicious tactics within the role, but still legal. But everyone within the law book of the book of law, everyone around the book of law already know that when you play your cards in court a certain way, you could tell if it's malicious or not. You could tell that, yeah, it's some dirty tactics that the prosecution and lawyers have available on the toolbox to either delay, postpone, disturb. Like they all are fully aware of dirty tactics. In my opinion, let me clear my throat. In my opinion, the judge know because he have to know. He have to know. he have to know what the prosecution is doing in the way they come into court and deliver their performance, the information they sharing, the information they not sharing. So it's very important here to be on record that we understand the judge, in our opinion, is being biased to prosecution. It seems like they both entities are working together to oppress and put pressure to the defense team. Keep the defense team always at last. Court prosecution knows what's to come. It seems like the court and prosecution agree with the tactics to follow for these procedures. I don't know if that makes sense to you. Comment down below. But again, it seems to me the court and prosecution already spoke about the tactics to follow. They already spoke and have an understanding of a bottom line for this case. So every time the defense team comes with their approach, the court and prosecution are trying to make Ann Taylor and her team look stupid. And that's purposely done. That's not by default. That's purposely done. That's dirty. That's a red flag. That's a no-no. Because the court's supposed to be unbiased, understand the record, understand the styles and the tactics, the techniques. They're not just the prosecution, but the defense team and the statuses. And the judge see very clear if prosecution is being malicious. Again, this is not the first time that Judge, Ann Taylor, and Bill Thompson being in the same room to handle a case. And I repeat, it's not the first time Ann Taylor, Judge, and Bill Thompson are in the same room. It's not the first time being in the same courtroom handling a matter in court. Other discrepancies from the prosecution. Big shout out, Joanne. Thank you for being here. You have not missed much, Joanne. We in the rice and beans, meats and potatoes right now. Big shout out to Joanne. Big shout out to Amy Conway. Thank you for being here. Big shout out to Super Creeker. You are a shooter. Thank you for being here. We appreciate it. And many, many others gonna trickle in. Can defense file for the judge to step down? Yes, Joel, I believe that what Ann Taylor has been doing is making sure that she have the judge on record and prosecution on record. Again, I was talking early about. Oh, thank you, Joanne. Thank you for being here. I appreciate it, though. Nice to see you. Amy Khan was very happy. She got her brothers and sisters trickling in. Actually, let me fix Joel's. Um, Joel being a moderator for a long time. I'm glad that he found the new page. No, thank you, Joanne, and thank you, Amy Conway, Joel, everyone here, very appreciate it. But I think y'all well know I'm feeling the motion to recuse this judge will be coming. Yes. Again, I believe that Ann Taylor just making sure that she have the judge and prosecution on record. She have to make record and case law. And so by the time she have enough substantial proof, undisputed proof that the court is being biased to the prosecution, things are going to move that way, it seems like. Because again, within the process of relocation for relocation of court or venue, they're already having problems with the survey when the survey is the product of the media, of the state's narrative. They fully aware of that. They actually talk about it in this one session right here. But I'm glad to see everyone here trickle in. Thank you so much. Very appreciate it. I know Amy Conway is very happy to see all her brothers and sisters trickle in. Thank you for your support. Thank you for being here. Very appreciate it. Make sure you click like, subscribe, and share the content. Big shout out to our superstar moderators trickling in. Very appreciate it. Do some housekeeping real quick. Making sure everyone is happy today. I'm glad that everyone is having a good vibe. It's Monday. Might as well start it with some good old homework and true crime. And have a great conversation of what's going on out there with this Bryan Kohberger case. Let's listen.
Now we want to do it once. Okay. So let me go first to you, Mr. Thompson, about when I know that it's been complicated, the discovery. I mean, you have these different agencies, FBI, state police, the state lab. We've got Moscow Police Department, Latah County, Pullman Law Enforcement, Pennsylvania law enforcement. And I think you mentioned it's hard to get all this stuff together. And that is one of the things that has delayed setting the trial. Not to mention the motions about the grand jury procedures, also the issues about the investigative genetic genealogy issues. And I'm kind of curious, okay, when do you think that you will be completely finished with providing discovery to the defense?
Judge, most current projection that we have would probably be at the end of the summer. The majority of the discovery has been provided. That's not to say that Mr. Kohberger has been able to, and his defense team been able to digest it all, because it is substantial as an understatement. We are still awaiting information that the defense both wants and needs to have.
Thank you. Very appreciate it, Amy. Amy on point. Thank you so much, Amy. Thank you, though. What I was saying is this is something very, very bad about this. Because they say that they should be ready with all the discovery by summer. And then he said that the amount of evidence is overwhelming. There's something wrong with this. Y'all remember like all these terabytes and all these stuff, the all these hard drive of evidence and all this other stuff that they have. That don't mean that is evidence against Kohberger. That just overall whatever they gather. That not necessarily means that that's proven evidence against Mr. Kohberger. So I believe, this is my personal opinion, no one need to go crazy, okay? No one need to go crazy. But in my personal opinion, due to the prosecution lack of evidence, this is the reason why they making it seem like they have so much evidence to gather from all these agencies that in reality they don't have nothing. Because if they had it at this day today, everything would be, and this is a fact. This is a fact. This is a fact. They had long enough time. In the same way they hurry up. And when they grab Mr. Kohberger and lock him up, in the same way they needed to hurry up to get him prosecuted, to do justice. That's the bottom line. Let's continue.
And we're going back through all of the discovery to make sure that nothing's been overlooked. We have two members of our team, an attorney and a legal assistant, who are essentially assigned full time to that task. And that's projecting we got from them. It could be up to 6 months, which would put us with initial discovery completion at the end of August, 1st of September of this year.
Because last time you were talking about August for the trial.
Sure enough. And that's what we had hoped for. And when we filed our motion for trial setting scheduler back in December, a couple months ago, we felt that was realistic. And as we are looking at where we are right now, I'm not sure that it is. We know that the defense has already indicated that just on the death penalty alone, they will be filing multiple motions, and they've been very lengthy. We've seen the same filings in the Nez Perce County homicide case that recently resolved. Those I could see taking a couple months in and of themselves to address, in addition to motions that actually directly relate to the merits of this trial, discovery, motions of limine, and that sort of thing. Our team met again this morning with our companions from the chief's office here in Moscow, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested. I'll tell you before you say anything about that.
Yes,
I was looking at whether or not it was realistic and fair, okay, trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, it just happens to be in pink highlight on my ad here, March 3rd, 2025.
March 3rd, 2025, prosecution and the court already had a lineup. This is bad, and this is on record, guys. This is bad, and this is on record. Prosecution and the court already took the decision way before this hearing. They already had a date to start the trial behind everyone else's back, behind the defense team and behind Ann Taylor, is on record. And this is proof. It's not coincidences. It's not like, oh my God, you read my mind. Oh my God, you read my mind. Me and you, eye to eye, amigo. We are not that stupid, though. Let's make that clear, though. We are not that stupid, though. And it's the reality. We are not that stupid. We understand what y'all doing. We understand. And it's very clear, it's very out there, and it's on record. It's crazy to see. It's crazy to see how prosecution and the court is in such a cahoot. They have a date for trial already talked about and noted as the best day option without the defense team. With no type of conversation with no one else but between themselves. I'm gonna play that back because I want them to be on record. You're listening to this analysis in Jrod on Point True Crime.
Sure.
Because last time you were talking about August for the trial.
Sure enough. And that's what we hoped for. And when we filed our motion for trial setting scheduler back in December, a couple months ago, we felt that was realistic. And as we are looking at where we are right now, I'm not sure that it is. We know that the defense has already indicated that just on the death penalty alone, they will be filing multiple motions, and they've been very lengthy. You've seen the same filings in the Nez Perce County homicide case that recently resolved. Those I could see taking a couple months in and of themselves to address, in addition to motions that actually directly relate to the merits of this trial, discovery, motions of limine, and that sort of thing. Our team met again this morning with our companions from the AG's office here in Moscow, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested.
He said, I'm very interested. The judge said, I'm very interested. Acting like he don't know what's coming. Like he just playing his role right now. This is not good, though.
I'll tell you before you say anything about that.
Yes,
I was looking at whether or not it was realistic.
So the judge is taking charge due to the judge know they will make him look bad, saying that, oh, I have the same day you have already planned it. The judge stopped the prosecution from talking, and now he's taking charge on that it was the court idea of imposing this one day because the court seems fit utilizing this one day, making the prosecution look good, like, oh my God, we had the same day and schedule for it. This is the day that I wanted to talk to you about, Judge. So it's kind of like you see the friendly cahootness between the court. The judge knew that the prosecution would have looked bad. Actually, the court would have looked bad. And actually looks worse because we caught it anyway. He's taking charge on promoting the day to follow for trial. And then the prosecution gonna be like, oh, judge, we had the same idea. Oh my God. This is ridiculous.
And fair, okay, trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, it just happens to be in pink highlight on my ad here, March 3rd, 2025 for trial.
Okay, I had no.
We don't believe in coincidences. And the judge realized, he know he's caught. He know he's caught. It was a bad idea. He shouldn't know that. Yeah, Joel. Not very impartial at all. Listen to this.
No idea. I wasn't reading your mind or anything, but I thought that's about the mid. And I remember I was looking at whether or not it was realistic and fair. Okay, trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, it just happens to be in pink highlight on my ad here, March 3rd, 2025.
Are they busted? Aren't they busted? This is when we do homework. This is when we do homework together as a community to catch even the court in cahoot with the prosecution. And he's there.
Okay, I had no idea. I wasn't reading your mind or anything, but I thought that's about the mid. And I remember, Ms. Taylor, that you said that would be the soonest you could be ready.
And that was if everything went right from that point.
And I remember that.
And it has. It has. But I'll hear what their proposals are.
Okay. Go ahead, Mr. Thompson.
Thank you, Judge.
So Ann Taylor is fully aware of the intentions of the prosecution to delay, disturb, delay. Because this is all they have done. Meanwhile, they try to make the defense team look like they ignorant, they toddlers. It's because the prosecution know that they have the upper hand utilizing the court against the defense team. And it's out there for everyone to see. We're just breaking it down and taking a look at it and giving you our honest opinion of what they showing us or what they showing to the world. This is out there for the world to see. They cannot even be mad at us for having an opinion that is very unbiased and is due to their performance in court. They are on record being biased, the court and prosecution in cahoot with the defense team against the defense team. They making the defense team look like toddlers. like they're incompetent. We in reality, in my opinion, who's not really who's really not proposing to move everything along in this process. The only people that wants everything to go and follow through is the defense team. And again, Ann Taylor said it very clear. For that day, I'll be ready if everything that y'all said that y'all going to do, y'all do it. Is having full discovery and everything else that she has requested for the court to look at and decide upon it. But it seems prosecution had all the will to stop the process. That's unfair. This man is being locked up for a year already plus. By the time he gets to see justice, it's going to be 4 to 5 years.
So we would propose that the court set March 3rd of 2025 as the start of trial. We would propose a September 6th, 2024 preliminary discovery deadline that would include exhibits known at that time. November 8th, 2024 for the defendant's discovery deadline. That would give them a chance to respond to any last minute discovery that comes out from the state. February 7th of 2025 for the state to disclose any basically reply or rebuttal to what we've learned from the defense discovery. That would include rebuttal experts. The defense's deadline would also necessarily have to include their mitigation evidence. We would suggest the court consider a final pretrial conference, kind of the pretrial wrap-up details conference for the week of February 12th to 16th, 2025. Since the death penalty related motions are already known and they aren't dependent on discovery, we would ask that any death penalty related motions defense have be filed by September 6th of this year. That the state have until October 11th to respond. The defense can then reply by October 25th and schedule a hearing during the week of November 4th through the 8th of this year. So we can get that wad of 12, 18, however many of those motions are going to be filed, we can get that handled. We would suggest that the court direct the jury questionnaires, if we can't agree on one, that the record suggestions from the state and the defense be to the court by November 1st of this year. That would give the court the opportunity to finalize a jury questionnaire that the court is comfortable with, and it can be ready at the start of the next calendar year, which is when the next jury pool would be polled or would be drawn. And the court can, at that point, get questionnaires out to an initial panel and can assess in a timely fashion, are we really going to have venue issues in the early part of next year as we approach March 3rd. We propose that jury instructions, exhibit lists be exchanged by January 31st of 2025. And finally, as to pretrial motions, which would be case-specific motions in limine and those sorts of things, the deadline for filing, that would be November 22nd of this year, with the understanding that parties could file them early. And the state already has been developing a list of various pretrial motions in limine that we think we'd like the court to consider, and file those early. But the deadline would be November 22nd, responses by December 13th, replies by December 20th, and then schedule a hearing on any of those pretrial motions sometime during the week of January 6th through the 10th. And I think
You have to write that down.
I have it all written down.
Started.
Yes, sir. And we can get it to you in writing. That's not a problem.
Okay. Ms. Taylor, so if things aren't going perfectly, of course they never do.
They never do, Judge. They never do. And I'll say it again. Death is different. This is a capital case. I've heard the court say the court only wants to do it once. I've heard the court ask, what can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Bryan or used in the investigation, I need that stuff. I need, when I ask for something, I need to get it rather than have to go back and ask and ask and ask again. And I'm not saying anything mean about Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some.
She's giving, you see, one thing that people don't see, that she's giving Bill Thompson like a respect level. Like, you know, she has called him out already on record, but at the same time, she's gracious enough to give the man some respect. And she's not saying that he's the problem. She's saying there is a possibility that the agencies involved within this case are the problem, which delaying the information they need to provide to prosecution for the prosecution to deliver to the court and Taylor to then decide what's going to be used in trial or whatnot, because it's going to be motions against evidence. Prosecution knows that it's going to be some motions against something. Like, again, the IGG is not going to be used, but it has a effect in this case. Again, the IGG was the reason why they put handcuffs on Bryan Kohberger, but then now they're not going to use that on trial, and they needed to let Kohberger free, because again, it's like the state was like, well, we're going to pinch him with the IGG. As soon as we arrest him with the IGG, we're going to use the IGG as the excuse to arrest, and then we're not going to use it in court, because they know they cannot use it in court. But they use it to catch him and trap him. And then now that he's trapped, they're not going to use the IGG. But then Kohberger got arrested due to the IGG, and the IGG is not going to be used in the court on trial. That's a discrepancy. That's a illegal loophole, which is dirty, which the judge is fully aware due to that he has seen the full totality of the IGG. The judge is aware of the dirty trick to capture Kohberger using the IGG while you don't have nothing else to have a warm body to calm down the community and make the university look good and look safe again, because you have a body. So you just went to trap a body and then delay everything else because you don't have no proof against that warm body. You trapping, you kidnapping a human with a dirty IGG trick. And obviously you're not ready to prosecute because you don't have nothing. If you have anything, that would be on your table a long time ago to prosecute. This is, I believe, what was going on when Bill Thompson said that pretty soon the court have a bigger issue to deal with. The court knows that the only reason Bryan Kohberger is locked up right now is because the IGG. The IGG is not going to be used in the court of law against this guy in trial. They needed to make Kohberger free. Soon as the IGG was out the door, the judge needed to recognize that that was the only reason why Kohberger was arrested. And that was the only reason that why the grand jury followed through. And Taylor made a motion to dismissal due to the grand jury was not done right. and the evidence that the prosecution submitted, like the IGG, was not valid. The judge already seen the record. The judge know that they used the IGG for the secret indictment. So then the IGG was used to capture the guy, to come with a secret indictment, but then now it's not going to be used in court. Why Kohberger is not free? Because they don't have nothing else in court right now. Right now, as we speak, they don't have nothing in court. They will even be close of Kohberger being the guy. They don't have nothing but speculations, hearsay. This is a fact. Right now, as we speak, a IGG is not going to be used in trial, but the IGG is the only reason why this man is locked up and in court right now. How can any content creator could fight that? Is on record. The problem here is if the content creators don't pay attention to have a proper conversation with their community gonna be like a chicken with the head cut off, just fumbling around and thinking a whole bunch of nonsense. When if the content creator pay attention and deliver a proper understanding, their following, their subscribers will have a healthy state of mind and have a clear vision of stuff that probably they don't see the same way we see it. And just having a conversation about it and breaking it down to the atom and the common sense of it. A lot of viewership appreciate that. And we appreciate the viewership that actually see a value, not just clicking like, not just subscribing and sharing the content, but when they also show some love and hit the Cash App. Every time we come with the meats and potatoes, we see that people have a high level of appreciation. Again, we don't sit here and name everyone that they've been sharing their wealth and sharing their thought and sharing their experience while watching our show. I want to say thank you so much. Thanks to you. This show is growing in a great way. The family is growing in a great way, very healthy, very happy. And we try to bring and provide you the best content available and YouTube true crime. Thank you so much for your donations. It's very appreciated. Give me 1 second here.
Some examples. We asked for x-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again. And I'm not sure if I'm getting them or not. The response is we have thumbnails, but we haven't found the actual x-rays. There's one example. I asked for certain mapping data done by a member I do to speed things up.
This is a problem with some x-rays. I believe there is forensic x-rays that they needed, and they say they have mentioned it many times, but they say that they don't exist. So you don't want to share that with the defense, so the defense have a proper analysis of the wounds, to have a proper, complete, and total forensic report. That's a problem. It's like prosecution is hiding the truth.
I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI.
Let's be clear. Who said that Ann Taylor is not doing her job?
And I think
You have to write that down.
I have it all written down.
Sorry.
Yes, sir. And we can get it to you in writing. That's not a problem.
Okay. Ms. Taylor, so if things aren't going perfectly, course, they never do.
All right, let's be clear. Who tells me that Ann Taylor is not doing her job when she be roadblocked the whole way? Let's listen to her expose about where she's at and what's going on. People need to pay attention to the conversation and the language utilized to express her frustration about what's going on in the due process. There is no due process yet.
They never do, Judge. They never do. And I'll say it again. Death is different. This is a capital case. I've heard the court say the court only wants to do it once. And I've heard the court ask, what can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Bryan or used in the investigation. I need that stuff. I need, when I ask for something, I need to get it rather than have to go back and ask and ask and ask again. And I'm not saying anything mean about Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some examples. We asked for x-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again.
That's a red flag. That's a red flag. They gotta keep asking for something that is on record. And I repeat, why they have to ask and request for a discovery that it should be ready, that is on record. It does not looking good at all for the prosecution team at all. She's giving him his graces, but at the same time, she's being very direct to the court. Like, they never do. They never follow through. Like we being here, request after request, and it's like, what's the problem here? They should be ready, and they're not. But they making it look like you want to move on to get a day for trial that you're not ready. You're making yourself look good in the eye of the public, but you're not ready. It's like you lying to the people. They're ignorant. It's like you, as the state, and seems that like the court, are preying on the people's ignorance to get away with what they want to get away with, the narrative. The people that unfortunately are not thoughtful, for people that take everything on first sight by face value and doesn't challenge the narrative, don't follow the information and the protocols to make sure that the information that they giving to you is the proper information to follow. That's a problem. That's a problem. Prosecution cannot act like they ready to go, putting dates and everything when promoting speed, when it's very clear they want to do an ambush trial, bring evidence at last minute for the defense team to be on the fly and be reactive to the information the prosecution is going to bring up late. And the court is allowing that. That's a red flag.
And I'm not sure if I'm getting them or not. The response is, we have thumbnails, but we haven't found the actual extras. There's one example. I asked for certain mapping data done by a member of the cast team. They said, you have it all. I said, no, I don't. I only have November 29th. And they said, oh, well, I guess we just didn't get that. Something didn't copy right. And I'm not saying anything mean about Bill or his office. I'm saying this is really difficult to drag the information out and get it to my experts or to understand it. And to hear that we're going to have a discovery deadline by the end of August is great. I need to have every piece of everything. I then have to have time to double check and make sure I really got it. I need to have time to get it to my experts and for them to have an opportunity to understand how that impacts their opinions, if at all. So I'm prepared for this case. And then we need time to get things to the state and for them to respond to what we send to them too. I know that this court wants to set this trial. These kinds of cases don't happen in a year. They don't happen in 2 years. They take a long time. This case is challenged with the way discovery has come at us. I'll give you another example. I open up, I get them and I list them in my computer by date. At one point, I gave the court a printout of that so the court could see how I'm getting it. And when I look in a folder, it has subfolders. And I might get some reports from Moscow Police Department with an FBI report. And an FBI report might reference an email, it might reference a photograph, it might reference a screenshot of a picture or of a phone that they took when they interviewed somebody. That's not with it. So maybe a few months later, I get some photos that has these screenshots in. And now I have to try to figure out who gave that screenshot, whose phone did that come from, which officer did that interview, and get them matched up and figure out if it's somebody I need to talk to. So not only do we have a huge volume of information, the way I get it is completely disorganized. And it's like if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same.
And if you ask me, in my personal opinion, everything is done by design. In my personal opinion, everything is done by design. It gives me a very, very bad vibe. Like we don't want, listen, we support law enforcement. But at the same time, we understand that sometimes some law enforcement, they do things that they're not supposed to do. This case is giving me that feeling of when the cops are involved in bringing bad information to prosecution, put the ball in their court and make their move with bad information. And then now purposely they making it intricate. And at the end of the day, if you ask me, this is a incomplete investigation. Because again, Ann Taylor need to have everything on her table for this to follow. She need to have full discovery, full investigation from law enforcement, from all agencies. And then I believe when everything comes out in totality, it's going to be an incomplete. And I repeat, in my firm belief, by the time all the discovery comes out, I believe that it's going to show that it's an incomplete investigation. And that not just an incomplete investigation to have Bryan Kohberger there. Way before they get to Bryan Kohberger, the investigation to follow in the first 48 hours were garbage. That's my personal opinion. They have such a first 48, such a travesty as a first 48. Did they know their first 48 is garbage? Because in a week you clear shitload of people. Shitload of people. Having DNA to follow through in the same way you follow through with Kohberger, you were supposed to follow through with the other two DNAs and clear those people. It was no conclusion of those two other DNAs. It's no results, no investigation out of those two DNAs. They needed to follow through in the same way they went hunting down Kohberger with IgG, while they didn't do the same thing with the other two DNA within the same facility of Kohberger's DNA. Now explain that. And then if we call cover up, if we call the state law enforcement in the University of Idaho, tamper with evidence, put people in place to say the right things. Dylan Mortensen, allowing the change of alibi from someone that needed to be called a suspect day one. And everyone needed to be a suspect until they were clear after a proper investigation. What prosecution is hiding is the whole investigative process to get to Kohberger. Because again, you arrested Kohberger because the IgG is out of the question and he's still not free. So you trap him with the IgG. Now you're not going to use it in trial when you know that's all you have. Because everything you're going to bring to the table about Mr. Kohberger is challengeable in court. So at the end of the day, you waste all these taxpayer money wasting your time on a Mr. Kohberger that you're going to squeeze him for the next 5 years. And the victims will still not have justice after you have to dismiss due to lack of evidence after 4 to 5 years. In a way the prosecution is looking, in a way prosecution is handling this case, we talking about long run. We talking about three more years. (2027). I want everyone, Amy Conway, I want Joanne to please write it down for me. I will write it down. My forecast for final dismissal (2027). We're not gonna do no day, no month. But in our forecast, 2027 Kohberger's freedom. I want everybody to write it down. In our forecast, 2027 numerology, 2027 Kohberger numerology. I want everyone to do their due diligence. Okay? I want everyone to do the due diligence. 2027 Kohberger's freedom, because that's going to free the whole family. They're going to carry this cross all the way to 2027, when at some point in 2027, probably in the very January, that's a plus. The month of January 2027 is a plus. I'm gonna write down January. (2027) Kohberger's freedom. Possible January to be in the positive side, to be on the plus side. Our expectations for resolution for this case is gonna be 2027. At that time, at that moment in time, for a final dismissal, 2027, for these men to walk out free, 2027. Let's continue and listen to Ann Taylor, her expose about her expectations within the discovery.
That's what I'm doing. We also have science questions in this case. We have DNA, we have cell phone analysis, we have video analysis. The video analysis that the state really likes in this case, I don't have the full scope of that video with audio that should be available. They're working on it, they really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time. And then you have the public nature of this case,
which is one of the things the news media outlets, big and small, YouTubers, they have gone with the Kohberger guilty narrative. They mentioned the cell phone tower information, and they rely so hard on there is, for example, a cast done out there for the cell phone tower stuff. That's not even available right now as we speak. The video evidence of Bryan Kohberger vehicle is not even available yet. It's so much stuff that is not available right now, that how can the news media outlets or any YouTuber or any other platforms will say that Kohberger is guilty, then when at this day today is no solid proof. Everything available is challengeable. Is no solid proof of Kohberger being the killer, the soul by himself killer. Is no proof. Again, the car video, it have to show license plate, it has to show Kohberger driving it. It has to be some kind of sensor, roadside sensor, that it could be combined with the footage or whatnot. Because then if you see the vehicle driving through an area that it has a roadside sensor, the roadside sensor will take the information and the data from the license plates, and you'll know if whoever is in the camera was Kohberger or not. And then now is the question of, like, if that was Kohberger's video, I mean, if that was Kohberger's car in the video, then it has to be some proof that it was him driving the vehicle, which again, he already on his alibi, he said that he was driving around. So you might have Kohberger's video that confirmed that he was driving around at some time of the night, but then now they have to prove that Kohberger drove in the locality and that he entered the residence. You have to prove where he entered, what was the tactic and the method that he used to enter the residence. They have to prove that. It don't matter if you have video of his car driving around and it's him driving around, but then now you have to prove that he entered the residence. And again, it was no signs of forced entry, right? Now, either someone let him in, or somehow he knew that the sliding door didn't have no lock. That would have him as having prior knowledge of that sliding door not having a lock, and then have the fortune or the misfortune in this case of that sliding door not being secure. They need to prove that Kohberger drove by the murder scene around the time that he stated that he had 8 minutes to commit the murderers and get away. If you ask me, that's impossible. That's impossible to prove. It's impossible. You have to have proof, solid proof, that he drove around, that it was him. And then you have to prove that he entered the residence. Because if you can't prove that it was him driving around, and even if it was him driving around, you have to prove that he entered the residence and how he entered the residence to prove that he did the felony burglary, which became a felony after the killings. But you have to still prove the burglary side of things. It's just common sense. Let's continue.
Video analysis. The video analysis that the state really likes.
Video foreheads running from house on News Nation. Yeah, unfortunately, Amy, they running with narrative, heavy narrative that it being brought out from YouTubers. It's sad to say a lot of people believe that it was heads. Yeah, I know Bryan did cover it, but just because he covered it don't mean that that's anything serious. Again, we I want to make sure and everyone understand that none of the stuff that they talk about is on record as evidence in court. I want to make that very clear for everyone that at this day today still have the doubts. They talking about Linda Lane. They talking about Linda Lane be part of the Linda Lane footage, be part of the evidence. No, it's not. No, it's not. No, it's not. I'm gonna tell you right now, the Linda Lane footage don't have nothing to do with this case, and I've been telling you for a long time. Okay, Linda Lane came out after the gag order. Let's not understate that. All this video of the four heads running from the house and the Banfield footage, which no one is, if you pay attention, is really no one can really to the 100% then say that like, yeah, that's what's going on. In reality, let's face reality. No one can say that that was four heads. And even if that was four heads running away from the house, that don't mean nothing. Again, they talk about pieces of evidence that is not on the evidence pile within the court files. Look like four people running on my pointer. No, I understand. I totally understand that though. But in reality, the footage is not crystal clear. To be real and to be fair, the part that is the most important of all is make clear that when the Linda Lane conversation came all about, and when the information about this video and all this footage that they talk about, none of this stuff is on the evidence pile that will be used against Bryan Kohberger or anyone else. Not the Linda Lane footage, because the people was talking about, oh, the Linda Lane footage, it was leaked. It was a leak. Yeah, it was someone pissing on people. It's someone laughing at people pissing on them. Is the reality. Because the Linda Lane came out after the gag order, the non-dissemination order was already out. That means that anything and everything that it came out after that, saying that that was a leak of evidence, that would have got Mr. Kohberger free at this day today. Because they would have found out if that was true, that it was part of the evidence against Kohberger. If this video of Linda Lane indeed was anything that it has to do with evidence against Kohberger, this would have set Kohberger free. Because they would have found that, let's say, if it was Steve Goncalves, if it was the prosecution or whoever, or from wherever the leak came from, they would have got to the bottom of it. And Kohberger would be free right now at this day today. People don't understand that. This is simple common sense. This is why everyone that it has wasted their time even looking at the video of Linda Lane, you've been distracted to look stupid. This is not even my opinion. This is a fact. Because if Linda Lane was a leak against Kohberger, due to that is after the non-dissemination order was put in effect, this would have violated the non-dissemination order. They would have got to the bottom of it a long time ago. They haven't even talked about it. They haven't even talked about Linda Lane leak. Like, oh my guys, you have seen that just for a survey, they flipped out, right? Just for a survey, that it comes out of the consequences of the information the state has shared with the news media outlets. And they acted like they were enraged because the survey has such a questions. With those questions came out of the impression of the media, what the media has put out there. If they have problems with that, imagine if they in reality had a leak of a Linda Lane footage that he was about to be used in court against Kohberger. Just think about that for a second and make that make sense. For all those people that have wasted your time to looking at Linda Lane, Banfield footage, and all this other shit, none of this stuff is gonna be used in court. Because if he was about to be used in court, it wouldn't be out there right now. Let's make that clear. Okay? No, you're welcome, sis. You're welcome. I just want to keep everyone on the proper perspective of what's really going on here within this case. We need to understand that it's a non-dissemination order, and after the non-dissemination order came out and was put in effect, then the Linda Lane came out as a leak from the Goncalves. That's what it will say out there. That was a leak of evidence against Kohberger, that he shows Kohberger's car turning around and whatnot. That was a waste of time. That was to keep your focus on something stupid. Those content creators that wasted their time looking at the Linda Lane footage, they either did that purposely or they just don't know that it's really nothing. It doesn't make sense how a leak of any evidence against Kohberger, they will render a timeline of when this car drove around. And anyway, you can't even see a car. You see lights. You cannot make up the brand. You cannot make up the brand of the car. You just see lights turning around. That could be anyone. Just make that make sense for everyone that is listening to this right now. And I know you're probably gonna feel like a little embarrassed because, oh my God, but I wasted all this time looking at this one content creator breaking this time down about the video and with the sounds of the video and stuff like that. Well, you play yourself out. I'm sorry. Listen, you're a grown adult. You know when you fucked up. Just take it as a man or as a woman and move on, okay? Let's keep the conversation about the Linda Lane footage right there where it's at. Because I've been telling y'all, if y'all don't listen, that's your problem. You grown adults. We don't have no children here in this conversation. You know what I'm saying? We don't have no children here watching this show. It's all grown adults. So just take your losses. It's okay. Listen, you got yourself entertained looking at something that it make you feel like a certain level of satisfaction of knowing something that it was nothing. It's okay. It's okay. It happens. It happened to the best of us. You gotta learn. Because again, it was common sense that after the gag order came out, all this stuff came out, none of the stuff that is out there is valid. You know what I mean? It's just simple common sense. Because it would have got Mr. Kohberger free right now as we speak. So let's ease up and let's just pay attention to the details. Because it's a lot of content creators out there. They're going to try to keep you entertained with stuff that at the end of the day will not be no relevance in the decision making in court. You know what I mean? Which that's what we're looking for. We're looking. It makes sense now that you explain it, bro. Thank you. No, I got you, sis. I got you, sis. I just want to make sure that everyone has like the proper thinking about this, because again, if this information, these leaks, these alleged leaks came out after the non-dissemination order, they know for a fact if this was legit leaks, this has consequences in court, and those consequences could be Kohberger's freedom without a due process. You know what I mean? And again, they've been so worrying about a survey. Imagine how worried they would be of a leak of information against Kohberger that the defense team don't even have. Just think about that for a second. They would have flipped. Listen, they would have made the biggest issue of having a Linda Lane footage out there that he could be using against Kohberger, and the defense team don't even have it. Actually, it would be worse. And like they said, this was the Goncalves family leaking that. It'd be way worse if the family of a victim have this footage and this evidence, and the defense team don't even have it. You know the ruckus that they will made in court for this. Kohberger will be free next day. People don't understand that, and I know people is thirsty for information. And no, you're welcome. It just, I know people is very thirsty for information. I understand that, but is you got to pay attention in detail. You know, not get excited, too excited when something come out, when a content creator puts something out there to you. Um, you got to be very careful, because then you got to see the timeline. Okay, we have a gag order already put in place, and then this information allegedly is leaked by someone within the family, or the prosecution, which is stuff that don't even the defense team have. You know what I'm saying? You put two and two together. It's like how a content creator in YouTube will have this information and put out there in YouTube when not even the prosecution have this. Because if the prosecution would have it, they would have put a link to that. As soon as that footage will come out, would be taken down everywhere that it gets uploaded. It's just common sense, though. You know what I mean? Like the prosecution, listen, the state wouldn't allow no YouTuber to play stuff that is in record, that is part of a case. They not gonna allow no one to play for hours with a video in YouTube that they say is gonna be used in court. It would be taken down a long time ago. Why you think is a whole bunch of Linda Lane footage out there redone and remixed and re-edit? Because it's not part of nothing in court. If it was anything that it was useful in court for any decision, and it would not be in YouTube right now. I want to make that clear. Let's listen to what we have here to what's left, and I think that'll be it for today, because we got some good stuff covered, and we could leave some more material for tomorrow. So I want to come back tomorrow with the second hearing. I think we have covered this hearing very good.
In this case, I don't have the full scope of that video with audio that should be available. They're working on it. They really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time. And then you have the public nature of this case, and people don't want to talk to us. They're not wanting to talk to us. So we have to try to get witnesses, people that are listed in the state's discovery, to talk to us. We have our duties that are required with mitigation, because there's no break. I don't get to go to trial on the innocence phase, and then if something goes wrong and Bryan's not acquitted, I don't get time to go prepare that mitigation. I have to take another breath and start right there. So
I want to make sure that y'all understand Ann Taylor is working on a dismissal. This isn't what she's working, her the innocence face of it. She need information to challenge the state. The state don't want to give that information. She want a full acquittal. Ann Taylor's looking forward for a full acquittal. She has worked with the judge before. She has worked with Bill Thompson before. And when you hear Ann Taylor say, just give me what I need, I'm looking forward to a full acquittal. Why content creators are not talking about this? Why they don't give due respect to Ann Taylor and what she's doing? Why? Because she's a female? Because she's a public defender and everybody want to act like public defenders mean shit? Well, it seems like this particular public defender is certified enough to handle death penalty case. That's a big case. That's not just any type of other defense from a public defender. This is something that it makes a public defender a future DA, a future prosecutor, a future judge. Don't you think that Ann Taylor really want to put her foot down, to not say something I was about to say? But don't you think that Ann Taylor can't wait to put her foot down and show the whole world that we had a hoax created by the state in cahoot with the University of Idaho? I've been telling you, little by little, it's coming out. I'm still trying to figure it out if Kohberger don't have nothing to do with utilize him to waste government funds and distract the community on a trial that he know is not gonna get nowhere. For example, I don't want to believe that Bryan Kohberger was selected because he was part of the decisioning of we need you for a warm body. And by the time everything is done, you're welcome to the Illuminati. And by the time everything is done, yeah, of course she can wait. She, like she said at the hearing, I chose not to address the media and not to answer emails, and her choice. Yes. And Joanne, this is the confirmation for all the viewership, the things that is some content creators out there that I'm not gonna mention, but is some content creators out there that saying that they working with the defense, that they working directly with Ann Taylor. That's cap. That's cap. Is no content creator working with or for the defense team. Is no content creator that could say with truth that they working with Ann Taylor, because they don't want no contact with no one. The best thing that you could do is send an email, which I'm working on mine. The only thing that you could do is make yourself available for a conversation if they see fit. The only thing that you could do is make yourself available for a conversation if it's needed. And then the defense team and Taylor take the decision, either talk to you or not. But it don't matter what you put in an email and you send to Ann Taylor. They not gonna respond back. And she just confirmed that in court. So for all those content creators that saying that they working with the defense team, they expose. They expose themselves. Try to give themselves too much credit when they don't have nothing to do with what's going on. They selfish. They think it's about them. It's not about them. It's about these victims. It's about the fact that we see a delay of justice within the whole process of the investigation and the legal procedures in court. That's a fact. We seeing a delay of justice, which is not fair at all for the victims, and we need to make that clear. They have a clown show right now in court. And Ann Taylor could do only one thing, and is wait for the information that she needs to get to work. Let's give her due credit.
So I have to have time to do all of that. Our mitigation expert is working as quickly as she can. She is meeting a lot of resistance to collect records and to conduct interviews.
And there's another thing on record that the youngins from the University of Idaho, they all lawyer up. All the youngins around this crime, they all lawyer up. And no one wants to talk, at least to the defense team. No one want to talk. So that means that no one wants justice for these 4 young adults. We're talking about the same people that said that they were their friend or family member. They said they want justice for them. They don't want to talk to the defense team. I wonder why.
We're working through that as best we can. She has travel obligations to try to interview people. These things take time. I want all the discovery by the end of August. I love the discovery deadline by September 6th. That does not allow me enough time to get ready for trial by March 3rd. That deadline, that cutoff for us to get mitigation materials, that's impossible. That's just impossible. We've got the year pretty well scheduled out with what travel still needs to happen and what records still need to be obtained. So to have that to the state, I think they said by September, October, that's just impossible. I would request that this court take up our venue motion in May, make a decision on venue, and let's see where we can get with the discovery. I still need to read every bit of discovery that's come, and I haven't. I scan it when I get it, but to go page by page and read it and understand what it means, I'm not through 2023. I have a long ways to go. So I don't think that is realistic to set it. I think if you set it for March, I'm going to be back here after the discovery deadline, and I'm going to be telling you there's no way that we're going to be ready for trial. I would rather this court set the change of venue, make that determination. Let's see where we get with the discovery by May. Probably the court would have a decision by the end of May, early June. Let's see where we are with discovery by then and set a realistic day. I hope we can go by summer of 2025.
Well, thank you, Ms. Taylor. I I can help in any way to speed things with, if there's problems with discovery, I'm happy to do that on very short notice. Just so that we can keep going. But she said,
So the judge made clear that if it's anything that him as a judge could do to speed up the process of discovery, he'll do so. Let's see if he follows through.
it'd be fantastic if you got all the discovery by August. Your mitigation person has been working already, right? And just to know that.
But here's the thing: what y'all wearing, Judge? What you worrying about mitigation? Because mitigation is after the fact of the defense team recognizing that they don't have no defense. I know, Joanne. Yeah, it seems like. Because why the judge is worrying and keep mentioning mitigation? Why you as a judge, you worrying about mitigation? Because mitigation is after the fact that the defense realized through discovery and through analyzing the whole process. That's when they know if they have a case to fight or not. We have not getting there. Why the judge is worrying about the mitigation? Why they worrying about if the IGG is going to be used for mitigation, where IGGs don't have nothing to do with mitigation? Like, this is something that whoever been in court and have seen procedures in other courts and has studied case law, especially for this case, you could see that the judge either is incompetent or he's enabling the fuckery purposely while making himself look like he want to help, he want to speed up the process for discovery and all this other stuff, but he inserts a language on record. He injects, I'm gonna use his same terms, he inject on record the judge saying and mentioning mitigation. Why the judge is concerned about where the defense team is on the mitigation process when at this day today is not confirmed yet is nothing there that it has not been, like, the discovery has not been given yet. How you worrying about mitigation when the first A to B to C process is lacking? I don't understand the language that the judge is utilizing, when he utilizes it, and for the reasons that he's doing so. It's very intricate for people that don't pay attention, but if you pay attention, you see.
I'm not being insensitive about this. I did read the ADA supplementary guidelines for mitigation function of defense teams in death penalty cases, and it's huge. Okay, I get it. There are so many things that if you don't do, then it comes back as, well, you were ineffective. And those standards are high standards for sure. And it obviously takes a lot of time. So, but I'm also thinking, if you get all the discovery, if you can, assuming that, which may be inaccurate.
Yeah, Joanne, I paid attention to that. Yeah, they say he's not up to date in this case. But you see, if you ask me, in my personal opinion, this is just to make him look like he's not drenched. and soak in with all details. In my personal opinion, he's just making himself look like he's not to the 100% aware. And I think that's purposely done. He's making himself look like this senile, oh man, playing catch up. But how can he make himself look like a senile man that's playing catch up when he just showed the whole world that he's on point with the prosecution on trying to force a day for trial in March 2023 when no one is ready? How can they look so on point with each other, but at the same time the judge making himself look like he's not fully aware of everything, that he's not up to date on the case? A judge that is not up to date with the case has not performed in the way he's been performing. He cannot make no sense of that. How can you not be drenched of information as a judge for one of the biggest cases this courthouse has ever attended? That means that you are not willing and able nor qualified to take care of this type of case. I believe the judge ears is being filled up with a whole bunch of conversations from the higher ups. I think there is a lot of people on the judge ears. And I believe there is a lot of theatrics. Yeah, that I agree with you, Joanne. You know how the judge could say that if because by the time and point that the judge said what he just said about if in anything that I could help you out with the discovery, I'll do so. Why he didn't said that or did that by the second motion of discovery? Why we have all these bunch of motions for discovery and the judge has not put the foot down to make sure all agencies report to prosecution, so prosecution could report not just to the court but to the defense team to speed up the procedures, to speed up the process. Also, Ann Taylor stated we are still waiting on discovery that the state told us we are going to receive at the last court hearing and nothing. Yes, it's been oh my God, it's been like 2 to 3 hearings that they have said that they have some discovery coming, and they have not do so at all whatsoever. Big shout out to the people, 20 people watching. Big shout outs to y'all. Thank you for being here. Very appreciate it. Thank you so much. Thank you for being here. Make sure you click like, subscribe, and share the content. Very appreciate it.
The end of August, you're saying that you wouldn't be able to respond to all of that, assuming that it's even earlier, that you could not be ready for the beginning of March 2025.
That's exactly what I'm saying. I'm saying I love that discovery deadline. Let's shoot for that. And I think that would help me make a June 2025 trial. I think once we have that discovery, and I agree, we can file the challenges to the death penalty earlier, but the challenges to some of the things that are going to be contained in discovery, those we need to see it all and see how it interplays. I can do some things early, but I may be coming back and asking the court to reconsider if it doesn't go our way and we found something that we didn't have. I think a discovery cutoff is great. And I think the court has to manage that discovery. If we finally are up to the eve of trial and there ends up being a whole new dump of discovery, then the court has to look at that discovery and understand, is it exculpatory? Is it something that we didn't have a chance to prepare for and should be excluded? If it relates to anything to do with the death penalty portion of the case, then the court's going to be asked to strike the death penalty. I mean, the discovery deadline is critical in this case. So I love that. I love that. What that means, if I have all the discovery by the end of August this year, it means that there is a stopping point where I can know I have it all. So I can confidently get the motions filed. I can confidently tell my experts, this is it. This is the scope of what you have to do. And I can have some space to read it all and understand it and get ready for witnesses too. If the court makes that deadline, know that mitigation is not going to be done by then. But if the court makes that discovery deadline, and then we follow that with our motion practice, and then our deadlines for expert disclosures and whatever's going to come from that, and our mitigation,
I need to make sure that we make this statement. Ann Taylor have everything mapped out. People don't want to give her due credit, but she already have everything mapped out on her head. We could tell that. We could tell. Okay. Let's get that real clear. We don't see Bill Thompson and his team standing up and have everything already pre-seen and observe with a timeline of, if they give me this by here, this point, this is what's going to follow. It's crazy how some content creators don't give Ann Taylor the credit that she deserves, because she could only work with what she has available. Let's make that clear. Let's start there. It hit different. She have everything mapped out of how everything is gonna go if prosecution hurry up and get their job, their side of the things done accordingly. She cannot finish the stage of innocence for Bryan Kohberger for the motions to follow if she don't have all the information. It seems the prosecution gonna keep putting blockages for this information to come out. The deadline for August, the end of August, the deadline for that full discovery needs to be followed. And if by that deadline, the whole full totality of discovery doesn't show up, they should dismiss this case for lack of evidence. That's my take. Big shout out to Ann Taylor. I think she's doing a great job. And I believe that if anyone will prove to the court, and again, that's if, I want to make it clear, that's if the full total amount of discovery is not out yet, right? And I firm believe Kohberger is innocent for what we have seen at this day today. That don't mean that whenever the full amount of discovery in totality comes out, that don't mean that we might change our mind. If we see in that evidence pile something there that will be like, they will convince me like, yeah, he's cooked, then I will come here and tell you. But until, for what I've seen since the very beginning of this case, all the way up to this day today, is nothing there that will indicate that Kohberger was the killer? Nothing. Because everything that is out there is disputable, is challengeable in court, is nothing in concrete they will cook this guy yet. So yes, if we are very firm in saying that Kohberger is innocent on this day today, it seems like, and we're getting cooked by all the content creators and all the viewers that don't believe, due to obviously they either don't pay attention to detail or they just brainwash. But I repeat, up to this day today is not one piece of evidence out there that indicates that Kohberger is the killer. Because whatever is out there is challengeable, is debatable in court. Anything that is debatable in court is not solid and concrete evidence. That's when you have a slam dunk, when you have evidence that is undisputed in court. If they make that information available with the finality of the discovery, then we will analyze what is available and we take a decision and we'll see how the trial goes. But at this day today, innocent until proven guilty, in the innocent stage of this case, is nothing there yet that it will secure a guilty comeback from any jury, any unbiased jury. Let's make that clear. An unbiased, pure jury. Let's continue. We're about to finish the live stream. Thank you for being here. Let's finish the last details of what we got going on in this court date. And then tomorrow, the same time that today and yesterday, we're going to come back and we're going to have a finality of the court hearings and what we've been talking about Kohberger Idaho 4 case. Okay. Thank you everyone for being here. Let's listen.
Should be in good shape by June of 2025 to try the case. If we have that discovery come up, I think that's a great idea.
Ms. Taylor, Mr. Thompson.
Trying to figure out where to start first. Yes, discovery is massive. Yes, there have been things that Mr. Kohberger has asked for that we've inquired, and we were initially told, no, you don't have that. And then we have gone back at the prompting of defense saying, you sure? I mean, it ought to be there. And for example, x-rays for the autopsy. Well, we just got those. The first came in with thumbnails. In today's discovery, Ms. Taylor's going to have the full size, which we were able to obtain when we saw you gave us thumbnails. These are useless. Give us the real thing. And through the coroner's office, we were able to finally achieve that. According to Ms. Jennings.
So they said they got the x-rays. And Taylor had to make it such a big deal with the forensics for them to come up now and be like, oh yeah, and Taylor will get what she requested and da 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 da. But first they said it was not existent. Prosecution told her it's not existent. And they just came out with it. Busted.
We are better than 95% complete on discovery.
95%. Where is it? Did y'all heard that?
The first came in with thumbnails. In today's discovery, Ms. Taylor's going to have the full size, which we were able to obtain when we saw you gave us thumbnails. These are useless. Give us the real thing. And through the coroner's office, we were able to finally achieve that. According to Ms. Jennings, we are better than 95% complete on discovery. So we're getting close. There are some things that are outstanding. There are some issues with what information is actually available to us. We have given Mr. Kohberger everything that we haven't asked for a protective order on or had some sort of dispute about. And we've given it to them in the
Look at the language. Look at the language when they said 95% in totality. Look at the language when he said 90% in totality, and then he said that they have given Kohberger the majority. Listen, this is a lie, dude, and I don't know how Ann Taylor's not standing up and be like, "This is a lie, Judge." She really don't want to embarrass. She don't want to embarrass Bill Thompson. She don't want to embarrass the old man. But if I was her, I would stand up right there in the middle of the court, Judge. So I have 95% of the. So I have 95% of evidence. Because I believe if Ann Taylor had 95% of discovery, she wouldn't be this constantly requesting. Because at least she'll have something to be busy with for a while until the rest come. So I believe that if it's 95% that she has, and she still don't see nothing that it will attach Kohberger to this killing, I don't expect the other 5% of evidence to be any relevant to this case. If it's true that Ann Taylor have 95% of the totality of the discovery with her, and she's still saying that it's nothing connecting Bryan Kohberger, I don't expect the rest 5% of evidence bringing nothing in. This is why I believe that Bill Thompson is lying and Ann Taylor just don't want to expose the man. Be like, what you mean I have 95% of the evidence? What you mean? So you're going to tell me with 95% that I have is no evidence against Kohberger? So what the other 5% of evidence would tell you? Do that last 5% of evidence will cook Kohberger? I don't know. But if 95% of the discovery have nothing there, I'm not expecting the other 5% to have anything there. And I think that's why they hesitated to give that to. It's like, well, we don't have nothing, Judge. And I think that's the bigger picture that Bill Thompson was talking about, that pretty soon they're going to have to worry about. That, well, Judge, this is it. This is all we got. And the judge going to look at that and going to look at them like, oh, dismiss. And I believe Bill Thompson, if he don't retire before trial, he's going to get the biggest embarrassment ever on his career as a prosecutor. I think he's going to take the biggest L before he retire.
Frankly, in the orders come in, instead of waiting to try to package it together and give.
Oh, part 3 is going to be good. We're going to be talking about that last hearing. It's going to be good. We have it in totality. It's going to be fun. I think y'all going to love my takes on this last hearing. If y'all love the takes that I have so far, part 3, Linguinquisi, Moiselle V. Mortobello. It's going to be good manja.
To them in a different format just because they want it as quickly as possible, and I appreciate it.
Thank you, Amy, and thank you for being here, spending time with me. It's very appreciated. Same as Joanne and all the other viewership that we have right now as we speak. It's a pleasure for me to come here and give you some work. I understand we all love, the true crime drama and the fuckery is very entertaining, but I like when I give you the rice and beans, meats and potatoes. I feel that my job for what I came here for, which is give you the understanding and the analysis of my take in these cases for better understanding for the people that are paying attention to what I'm talking about. I love when I give you something to take with you that is going to be healthy for understanding. Because believe me, when people out there don't have the full amount of information to actually comprehend and understand the intricacies of something that is very simple, um, I believe that my job is done and well done when I could just break it down, little things that probably others has missed and overlooked. Because I like to pay attention to detail, and I like to make sure that I'm very clear when I make my statements and when I have a take on something that is very particular and very tough to talk about. That's why sometimes I'm very fearless about it. And I tell you exactly how I feel and my belief about certain takes that other content creators don't want to talk about. I believe that that's the difference between me and other content creators, because when I understand something, I like to bring that understanding to our community so they have clarity on something that they probably missing. Okay. So I appreciate you and thank you for spending time with us. It's very humbling and I appreciate you because again, we don't do much schedule or much live streams, but when we do, we want to make sure that we bring the 100% of potency in the conversation of these cases. Thank you so much and I appreciate you.
Appreciate that. And we're going to continue doing that. It's going to benefit to have deadlines for everybody to have to work for here. I don't think just setting a deadline for state's discovery does anything other productive other than that initial stage. So if we're going to set discovery deadlines, we need a state's discovery deadline. We need a defense discovery deadline within a reasonable time after that and a reasonable time before.
What you mean defense discovery deadline? Bill Thompson, what you mean with the defense discovery deadline? Because I don't know, Bill Thompson, what kind of training. And again, you're being 40 plus years rendering services to the community, right? So how come that you even make an emphasis on that when the defense cannot give you a response to evidence if they don't have the discovery? How are you going to try to implement a deadline on a response for discovery on the defense team when you have not give yours? It's like you can't listen. The defense team don't have to give you nothing. Why Bill Thompson is making it look like the defense has to give Bill Thompson anything. They don't have to give you nothing. Even if the defense team find who really killed these victims, they don't have to do that. They only have to secure Kohberger's innocence if it's any innocence there to secure. I repeat, the defense team don't even have to share with the state if they got to the bottom of who killed these victims. They don't even have to do that. They don't even have to do that if they don't want to. They just have to prove to the court Kohberger's innocence, and that's about it. So why Bill Thompson put on record on the transcript that we need to have deadlines for the defense discovery? What you mean? Whatever the defense discovery is none of your business. What? Oh my God, this is crazy. This is why some people out there are confused because they don't pay any attention to detail.
Trial, because we're going to then have to investigate whatever the defense tells us they might be using. And then, of course, an opportunity after we see what the defense is proposing or is disclosing to rebut that in some fashion and give notice of that. So that package of 3 days are important. Pre-trial motion on the death penalty, I think that's important. We need deadlines, so just get it done and over with. And both teams can prioritize based on the timelines what needs to be done when. I don't know the first thing about what's going on with defense's mitigation. Apparently it's been going on for a while. It sounds like it's going to be massive. That's something that we just don't have.
This is a problem. Why they keep worrying about mitigation when the innocent's face? They keep mentioning mitigation. Why you worry about mitigation when you not have secured the innocent face of this trial? Is it me? Is it me? Is it me? Or is these people that are working backwards? Are you serious? Yeah, both of them, the judge and the state. Wow, this is crazy though.
Any insight to. We think that our proposals are realistic. We appreciate the fact that something could happen where it turns out that they aren't realistic, that something happens and we have to revisit. And I think we need to be prepared to do that. I think the last thing that I want to touch on real quick is the proposal to set a state's discovery deadline and set hearings on the change of venue is inadequate. As we've indicated, change of venue under the law, that motion is premature. We need to be able to give the court the benefit of what impacts publicity, for example, is having on our actual jury pool. We know there's publicity. Everybody can agree. There's been massive publicity, not just in Latah County, but I see more about it in Boise or hear about it from other parts of the state and what we're seeing locally. And so the massive publicity, that's a red herring, realistically. There's publicity everywhere about this. The issue is whether the publicity and the nature of this case is
so the state recognize all the publicity that is out there. So the state is fully aware of the publicity and what is being said against Kohberger. How can the prosecution make a big issue of a survey that is the product of something that he's fully aware? Make that make sense. Make sense out of that. How you gonna complain of a survey that is the results of what you well know, the news media outlets out there, that the prosecution admit in this hearing they are fully aware of what is being talked about? How can they make an issue of a survey that is asking questions of the same things that you are fully aware that is being discussed in the news media outlets and other platforms? That's fugazi. That's dirty. That's malicious prosecution when you make an issue out of something that you already know is an issue that you started yourself. Law enforcement and state authorities sharing information with new media outlets so they could talk. This is a problem that you, Bill Thompson, started. So how you in this hearing, you're gonna admit that you are fully aware of the publicity everywhere, but then you're gonna make it such an issue of a survey that you know is coming out of the public opinion of what is out there in the news media outlets. I wait. Is it me or is them? I'm only speaking in reaction on what's going on here due to the information that I do have about this case, the homework that I have done in this case. After the homework is well done and accomplished, then I could sit here and analyze everything that is being talked about in court and everything that is being talked about in the news media outlets and YouTube, let's say. Amy Conway, Dirty Tactics, I think for motion to move venue, needs 2 polls to present the defense and finish one state. Duty stop. Then for doing the second ammo. Yes, I totally agree. The state should have their own survey. They shouldn't worry about the defense survey. And they just should go at it. Decisions in court. State with their own survey instead of complaining about the defense team survey and complaining about that. They should let the defense team do whatever survey they have, because they know for a fact this is information that is out there in public record. So the state could just do their own survey, the defense do their own survey, they bring it to the table to court, let open the record on file in front of the judge, and let the judge take the decision. It's that simple. They created a big issue out of no issue just to stop the defense team from working their case. That's malicious. And people need to understand what the court is doing against Mr. Kohberger and against the victims, because this only postponing and delaying justice for the victims.
Such that we cannot pick a fair and impartial jury in this county. And of course, we know that just being aware of publicity about a case does not disqualify a juror. There has to be a showing that that publicity or whatever has impacted the juror to the point where that juror cannot sit in this box as a fair and impartial juror and make a decision based only on the evidence presented in this courtroom. That's the issue that Your Honor is going to have to decide on the change of venue question. And you can't do that based on a bunch of affidavits from experts who say, Judge, there's been a lot of publicity. That doesn't cut it. So I think just having a state's discovery deadline and trying to prematurely move forward with motion for change of venue is not the right approach. We think that the proposals that we've made are reasonable, understanding Ms. Hayward has concerns about whether she's going to be able to meet those. And I think there are enough stages in there that if that becomes a reality, there's the opportunity for us to discuss that. Like everybody here, we only want to do this once. We do not want to invite error that we can avoid. Thank you, sir.
Yeah, thank you, Mr. Thompson.
Oh, Bill Thompson is so energetic to have a proper opinion on the change of venue. But then when the defense team bring their survey, which they have a clear cut understanding of what's out there, he freak out. made an issue out of a non-issue because you're getting the information that you requested for a decision of the change of venue. It's just that you don't like in the way the questions were laid out and the type of questions. But how can you make an issue out of that? But you don't make an issue on the public and the publicity out there about these cases in the news media outlets. How can you make the survey a problem and an issue, but you don't make an issue out of the same information that you as the state? Because again, law enforcement representing the state. So whatever law enforcement have give on the name of the state to news media outlets, that's what is out there. It's your fault. Because if you were so worried about the narrative that is out there, you should be worrying about what Nancy Grace and Megyn Kelly and News Nation and JLR and all these dumbasses are talking about. You should worry about that. You should call them and get to the bottom of how they get their information. If you're not worrying about that, you shouldn't worry about the survey. You're being a hypocrite, Bill Thompson. A hypocrite.
Okay, I think you said maybe you're like 98% on
But probably a little bit more than 95% is what Ms. Jennings just told me.
95.
Probably a little bit more of 95% on discovery. Why the defense team don't have that? So you're gonna tell me the defense teams are a little bit more than 95% discovery? Cap.
Okay. So if it's 95%, I mean, is it possible that it could be done before the end of August?
It's possible, and we aren't going to wait till the end of August to do anything. We will continue to disclose information as we receive it. I mean, that's not fair to the defense. That's not fair to anybody. Just sit on stuff and dump it. So we are hopeful that it'll be finished by then, but we don't want to have to face a deadline that we think there's a chance could be difficult to meet. And that's why we propose the early September date, which would be essentially 6 months from now.
September 6th, that's what you're saying.
Yes, sir.
Ms. Taylor, you said that would be fantastic.
That would be fantastic, Your Honor. And Your Honor, can
Take notes. September 6th. Take notes. September 6th, 2024. So by September 6th, 2024, prosecution should have it all. I'm going to make a forecast on that. I believe by September 6, 2024, September 6, 2024, deadline for discovery, I believe prosecution will still be not ready. No full discovery by deadline. That's another forecast. We got 2027 for Kohberger's freedom around January 2027. And then September 6, 2024. My forecast is that at this day, September 6, 2024, prosecution will still not have available a full discovery, and we will talk about this by then. let's continue.
Can give us a January 2025 deadline if the court wants to set a discovery deadline for us too. Expert disclosures, I think maybe would take a little bit longer, maybe February 2025. The court gives us a deadline for expert disclosures. I want to comment on the motion for venue change.
You see, we was clear on what we was talking about. The prosecution has to make available a full amount of disclosure of the discovery. So then Ann Taylor and her team goes to work, and then they render the response to the prosecution. The prosecution act like, well, if judge, if you're gonna give me a deadline, you got to give him a deadline. Like he's a little kid. Like this is child's in court. Oh, if you give me a deadline, you got to give her a deadline. What the fuck is this? The deadline that we have to worry about is your deadline, Bill Thompson. That's the deadline that we have to worry about, because without your deadline, without your information, defense cannot work. How can you worry about a defense deadline to respond to you when you don't have what the defense needs to get to work? What a doofus. I have to say it. What a doofus. I had to say it. I have to say it, man. It was burning inside of my chest, man. No Diddy. Bill Thompson is a doofus.
Because I filed a motion and the court doesn't have affidavits or the briefing to understand how we're going to approach this, doesn't make it untimely. I'm fully aware that the massive amount of media coverage by itself isn't all of it. But I'm also aware that this case has had more media coverage than most other cases, and it continues. So there is an impact of that. There are other considerations besides just the massive amount of media and an impact on potential jurors. That's what we're going to talk about. I think it's timely. I think it's appropriate to set a change of venue motion. I think it is what makes the most sense for the court to make that determination and set a trial date from there. If the court sets one here and has to change it later, a lot of things have gone into play to get that trial date set here, to get the courtroom reserved, and a lot of people realize waiting until the court has heard the information, more than affidavits saying there's mass amount of media coverage, the court can make that determination. If the court agrees to change venue at that time, then it makes a lot more sense to just set that trial from there. I would think by the end of, or by May, when we can have a hearing, I would think I would have a better handle maybe on the process the state's going through now with its discovery. I will continue to make the utmost effort to get all the way through every piece of what I have now and continue to follow up with questions to the state so that we can try to have this discovery issue put aside. Once we have the discovery completed, I think that we're going to have a lot better idea of what the motion practice is going to look like and how long that's going to take. And it'll be a more realistic way to disclose experts to one another with the materials that's required under Idaho Rule of Evidence 702. I think that's a better way to go, even though you might not set a trial date today, because at least you'll set one that's really informed that maybe everybody can rely on.
Thank you. Well, I want to make an informed decision about changing venue, and it makes sense to me. I mean, it may be premature, but I'd like to see what the defense has to say about that, what you're going to present. So, unless I'm just curious to hear this, I can always deny it. But if it's sufficiently strong and persuasive, then maybe it makes sense to do that. And obviously, when just for personal reasons. I didn't particularly want to go to another county. Well,
Did he just say for personal reasons? So you being biased. Hold on. He said that for personal reasons, he don't want to move what?
I think that we're going to have a lot better idea
Let's pay attention in detail to that.
of what the motion practice is going to look like and how long that's going to take. And it'll be a more realistic way to disclose experts to one another with the materials that's required under Idaho Rule of Evidence 702. I think that's a better way to go, even though you might not set a trial date today, because at least you'll set one that's really informed that maybe everybody can rely on.
thank you. Well, I want to make an informed decision about changing venue, and it makes sense to me. I mean, it may be premature, but I'd like to see what the defense has to say about that, what you're going to present. So, unless I'm just curious to hear this, I can always deny it. But if it's sufficiently strong and persuasive, then maybe it makes sense to do that. But obviously, when for personal reasons, I didn't particularly want to go to another county.
He just said that due to personal reasons, he would not like to go to a different county. He just said on record, judge just said on record that for personal reasons, he don't want to move the trial outside of that courthouse. On record. The title of this live stream is Layton County on record with a biased judge. We just had accomplished to prove on record that our title was the reason why we here. We have on record a biased judge. The judge said on record that for personal reasons, he would not like to move this trial to other courthouse. Personal reasons. What those personal reasons, George? The University of Idaho? Because no judge should have no personal reasons for any type of biasness to keep a trial in their courthouse. The judge should not and must not say these type of things on record in court. The judge just said that he has a personal, besides his personal bias reason to not move this trial out of to other courthouse. Was that personal reason, Judge? You cannot say transportation. You can't say nothing. You was not supposed to say this on record. You was not supposed to say on record, Judge, that you have a personal reason to not move this trial outside of your courthouse. Is confirmed. The judge is confirmed. He's a biased judge.
Well, weeks, 13 weeks, necessary. I mean, we'll do what we need to do, but I'm not, as I sit here, I'm not persuaded that we necessarily have to change it. I think that's an automatic. And there are a lot of factors, and that's one of the reasons why I was looking at this patent case, which was that's Court of Court of Appeals, but it goes through all of the other cases that have dealt in this issue. So I'm thinking, you said mid-April that you would be able to file all of your declarations, affidavits, whatever you're going to do. Let the state know that who is going to testify. If you're going to have witnesses to testify, presumably experts. We got a taste of that, sometime at the beginning of one of our hearings. So maybe I'll hear the same witness. I don't know, but so we'll say April 17th.
Yes, I can make
Okay.
a proposal.
And maybe we say the state has enough time to have their response by May 1st. What do you think? Okay.
I think that's appropriate, Your Honor. Thank you.
Okay. Because there may be experts on the other side too. So, and I expect the information that you're going to present both sides and with a brief. So obviously. And I'm going to be in Boise the next week. You actually have other cases. Be surprised.
Why the judge don't want us to hear this?
How do you feel about afternoon of May 20th? That's a little bit far out, but we've already been talking about maybe having a trial starting in June. So
Your Honor, can I have it before May 25th? A witness I anticipate is not going to be available starting May 25th. Starting May 25th, I think for 2 weeks. So if I could have it ahead of May 25th, that way we
you have a
can.
jury trial back in May 20th. This afternoon of May 14 give you enough time, Ms. Beatty?
That was May 14th, Your Honor.
May 14, that's Tuesday.
Yes, Your Honor.
Okay, we'll say, how about 1:30?
Sounds great, Your Honor.
Okay, 1:30, May 14. I am going to make a determination about that presentation on change of venue before I set the trial. It could still be March 3rd, or maybe beginning of yeah, that's 2024. I know. I'm just still thinking of 2024. But it's hard. It is hard to think it is so far out.
But anyway, we could conclude right? But right now they're talking about scheduling and stuff like that. They're talking about scheduling at the end of it. So we could tell that all that got thrown out to the trash. All those dates that they give in this last hearing that we just seen right now. all those dates that they were talking about, all that stuff gets scratched up. Because we're going to see on the next upcoming hearing, which was the emergency hearing, we're going to take a look at it tomorrow. We will see that all these dates that the judge was talking about, everything got put behind. Because right now, in this latest hearing, the defense team got blocked for 2 weeks out of a decision that the judge took without no hearing. Again, I appreciate y'all. Thank you so much for spending time with us. It's very appreciated. If you see any value in the content that we provide here, please make sure you hit the Cash App. It's very appreciated. Make sure you click like, subscribe, and share the content. I want to send a big major shout out to Amy Conway. Thank you for being here and spending time with us. It's very so much appreciated. Also want to appreciate Joanne. Thank you so much for spending time with us. Thank you so much for everything that y'all do for our community, your community. We love you too, sis. Very appreciated. Thank you for spending time with us. Big shout outs to the whole family. Our super celebrity moderator, just as Joanne. All our moderators are superstars. Thank you so much for everything y'all do. Love you too, sis Joanne. It's very appreciated. We're going to be here tomorrow. Hopefully, I have y'all here in attendance. And we're going to sit back and talk about the latest hearing. And we're going to give you our takes. We're going to give you our takes and our understanding on everything. I promise y'all it's going to come, no Diddy, full circle. It's going to come full circle. Everything we've been talking about for the longest. At least we could say that everything has come full circle within our analysis and what we've been talking about this case. Again, I want to appreciate. Thank you so much, Joel. Still here, my brother. Very appreciated. Thank you for being here. Thank you for spending time with us today, Joel, Amy, and Joanne. Thank you so much. Very so much appreciated. We're gonna be here tomorrow. Thank you all the people that was watching today. It's very appreciated. All those likes, all those views. He's very humble. I appreciate you so much. And as always, your favorite brother, your mother's favorite son, the black sheep. The holds up the most, the thing to the tango, the yin to the jangle. Always here for y'all. Believe in yourself because I believe in you. If I did it, you could do it too. I ain't nothing special. I believe that you're going to take the best decisions for you and for everyone around you. As always, much love. Thank you for being here. This is Jrod on Point. It's a pleasure to be here with y'all. I'm going to leave y'all with your favorite song. And we close it for today. It's your brother Jrod. We love y'all. We're going to be here tomorrow.
Salga la luz, sexy millar, la que me tira a la guiña, aunque andes con su man, vamos a